So please keep yourself muted unless you want to speak. Try and use the chat. That way we can get through everything. We'll try and leave some time at the end for some questions. This is being recorded right now, so refrain from disclosing any personal details. Myself and the other family resource specialists are always here to discuss your individual issues with you, so keep that in mind. And let us know if there's any accessibility needs or any help you might need for using closed captioning. Knowing your rights, procedural safeguards. We've all gotten these, right? But did you ever look through them? So let's go over that. As always, the mission of the PEAL Center is to educate and empower families to ensure that children, youth, and young adults with disabilities and special healthcare needs lead rich, active lives as full members of their schools and communities. So our objectives today are to describe the rights of families and students through the use of the procedural safeguards under the Individuals with Disabilities Education Act, increase awareness of dispute resolution processes and alternative dispute resolution, and know where to find information about rights regarding school discipline, especially suspension and expulsion of students with disabilities. So your rights. So that's what the procedural safeguards are all about, describing your rights. So if you look on the actual document, if you have the document, the procedural safeguards in front of you, we're going to follow right along. The slides are all set up so they follow right along. Now, we're doing a general overview. Please know that this goes a lot deeper than the information we're going to share. We're going to let you know where to find it on the procedural safeguards and what's included in that area on the procedural safeguards. But there's a lot that goes into it that we just don't have time for in 1 hour. So let's start here. Parents must be given opportunities to refer their child for special education services. So with a simple email, you can let the school know that you want your child evaluated for special education. You have the right to participate in any decision-making meeting, including the IEP meetings, about the special education eligibility, assessment, placement of your child, and other matters related to the child's free, appropriate public education. Now, sometimes the school's going to have, some maybe meetings about academics or, something about kids in general. But if they're talking about your child individually, let's have a meeting. We need to talk about those things. You have the right to be informed of all program options and alternatives, both public and non-public. Sometimes you might have to make requests, especially for this information, but you have the right to know what those options are. So keep that in mind. You have the right to receive prior written notice in the language that you use when the school district initiates a change in the child's identification, proposes assessments, or change of educational placement in special education, refuses to initiate or change identification, evaluation, educational placement, or if you revoke consent of special education services. And again, there's a list of these on the procedural safeguards. So know that that's available too. One thing we do want to mention here is that in Pennsylvania, and this isn't like this in every state because there are some state laws that differ. In Pennsylvania, the prior written notice is the notice of recommended educational placement form. Forms are the same document. So, sometimes we use the words interchangeably or the terms or the acronyms, but they're used kind of for two different things. Prior written notice is, written notice that, proposal or rejection of a proposal, or as notice of recommended educational placement. So keep those things in mind. One second here. So you have a right to information in the language that you use. And if you're working with families, in the language that they use. It should be presented to you in a language you use at home. And this includes your child's language and communication needs. And it doesn't just mean, if you get a document and the document is translated, the content should be translated also. Oftentimes families will get the document itself translated into the language that they use. We need the content. So that's your right to have that done. If you need that, be sure to tell the school. If that's not happening, let us know. We'll help you work through that. For folks with deafness or blindness, or a person who has no written language, because some languages may be verbal, but they're not written. Excuse me, the mode of communication is whatever the person normally uses. These are important to keep in mind when you're reviewing documents or knowing that you have the right to do those things. Okay. Just trying to get things going here. Children must be assessed for special education using methods that are not culturally biased or discriminating. So know that that's a right too. The example that I always think of is, if we do a matching activity and there's a cup and there's a saucer. Well, some folks don't use saucers, or some children are not going to know what a saucer is because their family doesn't use that. We don't have any saucers in our home. So it would not show the child's, achievement if they had to match these two things and had no idea that they were to match. So keep those things in mind too. I'm not sure we're set up to do this. So let's just go skipping the Rights Done Right. If you look on our YouTube page, on the PEAL YouTube page, there is about 13 videos called Rights Done Right that puts all of the rights that are in procedural safeguards in, I would say it's fun, in a fun format to watch two parents engage in helping each other understand procedural safeguards. So you have the right to consent. A parent must be provided informed written consent before the child's evaluated or provided with any special education services, or before any special education services occur. You have the right to say yes or no to those things. The district has to make sure that parents understand what is happening in the meeting. Again, you have the right to be a fully informed decision maker. This isn't a place to be shy about asking questions. So if there's something you need to know, please ask those questions. Because you do have to be fully informed when you're agreeing or when you're providing consent. So, and this includes, arranging for an interpreter for parents with deafness or who speak a language other than English. That person has to be there. Oftentimes schools will use something like Language Line, where they're using telephone interpretation, which it does make for a long meeting, but this is one way that interpretation service is provided. And it's completely expected that parents who do not speak the language are also fully informed decision makers. Now, note too that you have the right to refuse consent. You don't have to agree. You don't have to agree to an assessment if you don't agree with it. There's some lines of thinking where an IQ test isn't really telling us anything that's going to help provide free appropriate public education to a child. In fact, an IQ test for some kids isn't going to be a true read anyway. So there's no reason really to even do that test. So if you don't agree with having a certain test, you can refuse consent to that. And, even let's say your child does have an evaluation and they are eligible for special education, you can refuse to have them placed in special education. That's your right. At this point, there's no guarantee from the school district for free appropriate public education. They don't have, that's, you're refusing that, so they don't have to provide what you would normally be provided. So know that that's true too, but you do have that right. I don't know if this is going to play if it doesn't look like it. Okay. So when is parent consent needed? So for an initial evaluation, that first one that's going to determine eligibility, we need to have your consent. They won't go further unless they have your consent for that. Consent for initial placement in special education to have the student begin receiving services. And again, for reevaluation. Now, there's kind of two types of reevaluation. One is where they're just reviewing existing data, reviewing things they already have on hand. That could be tests that they've taken. It could be homework they have. It could be in-class work that the teacher has. It could be, some of those tests that all the kids take during the school year. That's existing data. That's things they already have. So they don't need your consent for that. Sometimes during your 3 or 2 year evaluation, when they have to do a reevaluation, they'll tell you they have enough information. The school might tell you they have enough information from that existing data to write up a reevaluation report. But I'll just, suggest to parents, you've had 3 years pass, and there's a lot that's happened in that 3 years. You might not want to forego a full reevaluation in favor of this existing data. So know it is your right to have a full reevaluation done for your child, even if they do have some of that existing data and the school says, I think we have enough. You have a right to have that full evaluation. So what if you disagree with the evaluation that the school has done? And you have the right to disagree. At any point in special education, you have the right to disagree. So if you disagree with the results of the assessment that the district's done, you have the right to ask for an independent education evaluation at their expense. Now, this is truly independent. They may give you a list of evaluators that they're familiar with or have used in the past, but you don't have to go by what the folks that are on that list. The evaluator does have to meet the criteria of the district, which is usually just that the parent be a certified school psychologist. And there are folks out there who are doing that work specifically to do these independent evaluations. And there shouldn't be really any stipulations put on who you choose. It does have to be reasonable. So, if you're up in Lackawanna, you're not necessarily going to be able to say you want somebody in Pittsburgh to do your IEE. So, it has to be reasonable. And the parent's only allowed to have one IEE at public expense each time the school district conducts an evaluation with which the parent disagrees. So you're not limited to one throughout the child's school career, but you're limited to one each time there is an evaluation or a reevaluation done and you disagree with it. And there are lots of reasons to disagree with an evaluation. Let's say, you don't feel it's sufficient, doesn't describe your child. There was an important chunk of information that's missing or that's not correct. All these reasons could be a reason that you would seek an independent education evaluation. Now, at this point, again, keep this in writing when you request the IEE. The school district has to either see that the IEE is going to happen, or they have to, if they think that their evaluation is perfectly sufficient, then they have to request a due process hearing. They do. and have a due process hearing to prove or to have the burden to show that their assessment was appropriate and does not believe that an IEE is necessary. Often the expense of going to a due process, having the attorney, their school attorney involved, isn't as much as the IEE is going to cost them. So there are times when, the schools say, oh, sure, just get the IEE done. And it's usually helpful information. But other times they will disagree and they will file due process and they will take the parent to a due process. But again, they have the burden to show that theirs was appropriate. And note too that an IEE, again, this is a report that the district has to consider. And even though they paid for it, sometimes they might not use the information that's in there. That's a different ballgame. So the district also has the right to tell you how much it costs and provide a list of providers. Tell you how much it costs. Cost shouldn't be, a barrier to getting an IEE. But again, it does have to be reasonable. So that's what we're looking for there. Videos don't seem to be working. So we're gonna have, oh, wait. What do we have here? Let's see this one about independent educational assessments. Tell me if you can't hear once it starts. Oh, wait, I'm having trouble hearing. One second here. Oh, Cindy's just working. Best laid plans, right? Okay. Again, you can take a look at those on the PEAL Center's YouTube page. So know that you have the right to confidentiality. And, whether this is records or, there was one time when I heard some paraprofessionals talking at an outside event, and I could identify the kid that they were talking about. So know that you have the right to inspect, review, and obtain copies of your child's educational records without delay and no less than 45 days after you requested the records. Don't think you have to remember all of these days. I always say it's important to know that there's a timeline, and it's important to know where you can find the information about a timeline. It's not important to remember the numbers. But I did want to give you a quick overview of what the definition of educational records is. And according to ed.gov, so it's at the federal level, grades, transcripts, class lists, course schedules, health records, student discipline files, etc. Info may be recorded in any way. So all of these would be included in educational records. Handwriting, in print, computer media, video and audio, important to remember, film and email. Those are all considered educational records. So if you have a question about that, keep those things in mind. And things that are considered identifiable would be the child's name, your name as the parent, name of another family member, child's address, child's social security number or student number, or physical characteristics of the child, if you can identify them. Then that's all included in personally identifiable information. So if another person or an agency, and right now the only agency, there are other agencies, but when schools are monitored by the state, certain students' files are pulled for checking for compliance. So the Department of Ed may request to review child records And the school district has to, there'll be a list on the child's physical records, the names of the people who were viewing the records, the dates that they were viewed, and the purpose for their record review. And then you have, as a parent, have access to all of that information. So you can ask, why did this person view my child's records? And who knows when you need to, you might need to know that information, but know that that is available to you. If you disagree with information in your child's records, let's say you've looked them over and you find information on there that's not true, or something that's been resolved and it shouldn't be in there, you can request that the information be taken out or changed. I would always do these things in writing. That's the best way to ensure that, you have that record that's going to allow you to, use it as evidence if you need to. So within a reasonable amount of time, the school district had to decide whether or not they will change the information. And if they don't agree to change the information, then you have the right to a records hearing. Now, while I was doing some, deeper dives into this presentation today, I found that the person who was going to oversee the records hearing could be somebody from the school, and that it has to be ensured that that person, isn't familiar with, or usually sits on the IEP team, but it could be conducted by any individual, including an official from an educational agency or institution who does not have direct interest in the outcome of the hearing. So just be aware of that. Again, if you have questions about that, you can, write to the school, tell them, you don't think that that's appropriate. I don't know what'll be done after that, but know that that can happen. It's kind of interesting. So you have the right to file a complaint. If you remember last week, we had a session on filing a complaint, and you have that right. Again, the complaint is a way to improve programming. Complaint sounds like, oh, nasty word, adversarial. It's not meant to be. It's meant to ensure that there's compliance with what IDEA says, with what Chapter 14 in Pennsylvania says. It's meant to ensure that that's happening, and that that's happening for all kids. So the Department of Ed investigates complaints. At this point, a lot of our dispute resolution is handled by the Office for Dispute Resolution. But in the case of a state complaint in Pennsylvania, the Department of Ed investigates complaints. And they have to investigate complaints alleging violations of noncompliance with IDEA, so that's federal level, state special education laws, Chapter 14, and regulations, and issue a report of findings within 60 days of receiving the complaint. And again, doing some investigation, that's 60 calendar days, according to Procedural Safeguards. Again, you can view our session on filing a complaint. That's, if it's not on our website now, it's going to be on there because it was recorded. So you can file that. Filing complaints isn't difficult. In general, it's not difficult. And, I just was speaking with a parent who was on the fence about it and then decided to go forward with filing her complaint. And the districts, they're taking a great interest now in what she's found. And they're really, planning on working with her now. Sometimes that's what it takes. You got to take action to ensure that things are going to happen. Nobody says it's easy. It's not. But know that you do have that right to file a complaint. You have the right to a due process hearing. And, we usually think of this as This is not alternative or early dispute resolution. This is the big guy. This is due process. It is our right to have a due process. But it's also, financially, emotionally difficult. Schools will have an attorney there. I've seen a number of cases where parents, went pro se, meaning that they didn't have an attorney, they did it on their own, and they have prevailed, but it's hard. It's an official hearing. Instead of a judge, we have the hearing officer, but it is formal. They'll use, technical jargon. So keep that in mind. So let's talk about the resolution session first. So this comes before a due process, the actual hearing. So if you file a due process complaint, which is often confused with a state complaint, a due process, it is called a complaint, but it describes the nature of the problem relating to what the district proposed or refused to do, as well as describe what the parent wants as an outcome to be for their child. This is, again, another reason to consider having an attorney that's going to help you file the complaint, because if the district finds that the complaint is not sufficient, and again, technical jargon, what do they mean by sufficient? Then, they can file for non-sufficiency and try and throw out the complaint. So that's why, it's always a good idea to at least consult with an attorney. And once the district then receives the due process complaint, they have to set up a resolution session. So this is like a last-ditch effort to try and resolve the issue. We'll call together relevant members of the IEP team, see if we can come to an agreement. This process is set up so that we can try to resolve, like I said, last-ditch effort, one more try to resolving the issue. Now, regarding attorneys, if you decide to bring your attorney to a resolution session, you can do that, and the district will bring their attorney, but you don't have to. So if you decide that you're not going to bring your attorney to a resolution session, the district will not do that. They will not bring theirs. So that's, the rules around resolution. So let's say the resolution session is not successful. Then we're going to go through with the due process hearing, which includes an impartial hearing officer on the Office for Dispute Resolution website, which is odr-pa.org. You can see all the bios for the hearing officers. Right now, all hearing officers are attorneys. But again, they're impartial, they're non-biased, and same as any other judge or hearing officer, they're non-biased. They're not to be biased towards one side or the other. There is a 2-year timeline when the parent or the district knew or should have known about the issue. So, if you have an issue that went back, let's say, a year, then you do have time to file a due process complaint. You can go all the way back to 2 years of filing for a due process complaint. Whereas with the state complaint, you can only go back 1 year. With due process, you can go back 2 years to try and get remedy for the issue. Parent can definitely bring an attorney, provide expert witnesses. An expert witness would be anyone who knows of the situation, or I had my son had due process where we were talking about travel training. And, we brought in someone who was familiar with travel training. So any expert witnesses that are familiar with the situation, you can bring in. And Whereas most times, and I think we talk about this later, whereas most times if the parent prevails, they can get the attorney's fees paid by the district. Expert witness fees are not reimbursable. You pay for an expert witness. You have a right to receive copy of the transcripts of the hearing. Or when we went through the due process, they were provided us with at no request, but you can request a copy of the transcript of the hearing. There's a 45-day timeline to hold a hearing once the resolution session is complete. And again, if the parent prevails, they may be rewarded attorney's fees. It's a risk that you take, but can be worth it and can pay off in the end. That's the part we went through. So to me, this one should come before. Just excuse me while I take a drink here. So you have the right to mediation. And I know at the PEAL Center, we really push mediation at the parent's request because it is a helpful solution to resolution for an issue. This is a way to bring the team together with the help of a mediator, a trained mediator who uses some mediation techniques to help the team come to a resolution. So while the mediator, they might have some knowledge or background on special education, their goal is to have the team come to resolution. So that's what they work towards. So we know that it's voluntary. The district has to agree. The parent has to agree. There has to be agreement on both sides. But it's going to save a lot of time and money if the district agrees to do this and if it's effective. So the mediator is provided by the Office of Dispute Resolution, no charge to the family. And again, using some mediation techniques, they try and come to agreement. They're going to have caucuses where they might pull out the district. The mediator might pull out the district and have a, what kind of one-on-one with them and just see where they're coming from. And then they might go back and have a caucus just with the parent and whoever the parents brought with them to see if they can find common ground between what they've heard from the district and what they hear from the parent. And that's what they'll work towards, is this common ground. Know that sometimes, you're going to want to kind of negotiate or be willing to negotiate for what you feel your child needs. And, if you feel there's no negotiation, you might be headed to due process in that case. So note too that there's two types of mediation now. And this is really helpful for families. There's facilitative and evaluative. Facilitative is kind of what we've seen for years now. It's the mediator bringing the two sides together, trying to find this common ground. Where evaluative is where we look more at the merits of each side. What's the parent able to share to show that that there's an issue going on? What's the school able to share with what's been going on? And the mediator in this case, that's what their goal is again to try and help the team come to a decision, but they're using the merits of the case of data and information that the parent provides and data and information that the school provides to help the team come to resolution. It is different than facilitative. It's handled differently than facilitative. And in certain cases, it's going to be more helpful than facilitative. So I'd keep that in mind. You can call here at the PEAL Center to kind of weigh which might be better for you, or contact ODR's consult line and ask them, what the difference is, and they can try and explain that to you better. There is information on the ODR website to try and explain those differences and how that might work for you. So you have the right to have your child stay in the current program if there's disagreement about placement. If the parent disagrees with the district regarding their child's special education placement or a proposed change in placement, and the parent requests mediation or due process, that means filling out the forms, the student is able to stay put in the current program until the dispute is resolved. So, this is probably especially an advantage to families whose school might be suggesting a more restrictive placement, and the family knows what is best for their child, what's appropriate for their child, and that it's a less restrictive placement where the child's included. Then the family files a mediation and the child stays in their least restrictive environment that they're currently in. There is no movement of the child's placement until the resolution is resolved or until the issue is resolved. Very helpful in some cases. And again, all it takes is filing for those things. Hopefully there's, you can either use the mediation, either the facilitative or the evaluative, to try and come to a resolution where a child stays in their least restrictive environment and doesn't have to move. So that's the purpose of the stay put, so they don't have to move. You have the right to be informed of school discipline and alternative placement. This is a big one, and if you guys have been following us, you know that the guidance that we've gotten from OSEP in the last 2 years regarding discipline and behavior has been really important to us and to ensuring that our kids are getting an appropriate education. So, it is assumed that every child is going to have to follow the Code of Student Conduct, and that's going to happen. And when it doesn't, that there is discipline that often takes place. So a student with a disability may be suspended or placed in alternative ed settings to the same extent as students without disabilities. In the, at the top, make sure that you're aware of that. But there's also some differences. So if a child with a disability is in an alternative placement for greater than 10 consecutive days, an IEP meeting has to be held to consider the appropriateness of that placement and the extent to which the disability is the cause of the misconduct. And again, we talk about this when we're talking about that's discipline and behavior, that, even if it's not consecutive 10 days, but you're looking at a pattern of a child being placed in a exclusionary setting, or if it's, greater than 15 days where a child is being placed in these more restrictive settings. These are reasons for the team to come together and say, what isn't the child being provided? What supports aren't being provided that the child needs to have in place, needs to have in the IEP to ensure that they are getting their appropriate education. At all times, the district has to provide a free, appropriate public education. So important things to keep in mind. And again, if you, maybe Heather, that's one of the links we can provide is the OSEP guidance on discipline and behavior. That's been a really great resource for families. If you read the Q&A on that site, it's really helpful in, helping inform the team if maybe the school doesn't know what they should be doing as far as providing support for our kids when there may be behavior issues.
Got it.
Thank you. So regarding private schools, usually the general information about kids that are parentally placed in private schools is that they don't have any rights regarding IDEA. Well, they do have limited rights. School districts are still responsible for identifying, locating, and assessing students with disabilities enrolled in private schools by their parents. This is called child find in IDEA. And even if a child is in a private school, they still have the right to be evaluated for special education. This is part of that, a parent being fully informed. If the parent needs to be fully informed in order to make decisions about the child's placement, they need to know what issues does the child have, what needs do they have, what could be provided in school, in a public school that can't be provided in a private school. So they have the right to an education evaluation. School districts are not required to provide special education or related services to students who are in private schools. Even if they do an evaluation and they're found eligible, the child would have to go to the public school to get the services that are outlined in an evaluation. And you can go as far as, writing up an IEP to see what would a child's IEP look like if they were in public school. So that's still while the child's in private school. The team can say, okay, let's look at what an IEP would look like. And again, it's because you need to be a fully informed decision maker as a parent to say, okay, do I want to keep them in private school for these reasons, or do I want to put them in a public school because they could get these services while in the public school? So again, that's, a choice a parent would have to make regarding what could be provided. So while there's no entitlement for services, some private schools might receive some services from the school district. And this could be through, I don't think we have a slide that explains this, but it could be through equitable participation. Equitable participation is when the intermediate unit has an agreement with the private school to provide services to probably what the school would say is to a good number of students. So if a number of students in the private school were experiencing reading difficulties, then through equitable participation, which is just a percentage of IDEA money that the IUs have to put towards educating kids in private schools, an agreement between the IU and the private school could say, okay, we're going to provide reading support to kids at the private school. So it's an agreement, and it's not specific to any one student, but usually it's to what's going to benefit the most students. Sometimes it's speech services because there's a good number of kids that need speech services. So again, it's an agreement between the private school and the IU about what's going to be provided. Through dual enrollment, a child could be enrolled at both the private school and at the public school in order to get special education services. Now, the public school would have to agree to this. And in cases like Pittsburgh Public Schools, they say that this is too much of a burden for them, so they will not accept dual enrollment. They can do that and get that okay from PDE, but you'd have to check with the school district specifically to see if they accept dual enrollment. The student would have to go to the public school to receive the service. So let's say it's for occupational therapy. The student would have to go to the public school for the services. Transportation may be provided. But it would take probably a good chunk of their day. So it's again where the parent has to weigh what's going to be most appropriate for my student, for my child. So it is something to consider and know that those services are available to kids who are parentally placed in private schools. But again, parent has to consider that. So I did want to go through too, and this is always a question that comes up, and we found some information while going through the procedural safeguards regarding weapons. So when we were talking about discipline issues, a lot of folks say, well, what's considered a weapon? I mean, we hear stories out there about, kids getting in trouble because they had a squirt gun. So I got this information from the Education Law Center in Pennsylvania that talks about weapons at school. And it tells us that the law defines a weapon as any knife, cutting instrument, cutting tool, nunchucks, why those are in there, I don't know, firearm, shotgun, rifle, or any other tool, instrument, or implement capable of inflicting serious bodily harm. So interesting too, in that same fact sheet are objects that are not considered weapons under Act 26. Objects that are not inherently dangerous, including objects regularly found in school. And we've heard horror stories around this too. So books, backpack, cafeteria tray, ruler, these things that kids, pencils, things like that, not considered weapons. They're in schools every day. Can't consider it a weapon. Items that are used as part of an approved school program. The example that they use is a saw that's used during woodshop. Or the replica of a weapon. So a toy gun, model rocket, etc. Those toys are not considered, for the purposes of discipline in school, are not considered weapons. So if you have questions about that, again, here's the contact info for the PEAL Center. I encourage you to get information there. Along with the procedural safeguards, there are forms, if you download this from the PDE website, there are forms for due process complaint, which again, I'd really consider, talking to an attorney or even retaining an attorney if you're filing for a due process, just because of the situation. Our due process was a rather simple one, but I don't think there was any way I would go through it without an attorney. And there is a request form for a mediation, which again, mediation, simple. It's kind of a fancier IEP meeting. I mean, you have that third party that's there in the mediator who's there to try and, bridge a gap, and just a very effective way. We're talking about close to 80% success in Pennsylvania regarding mediations coming to a resolution. So I think we have some. Now you want to scan this. This is our evaluation. We need that evaluation to share with our funders, to tell them, sharing good info here. People need the info that we have for them. So you want to scan that. Just open your camera, place it over the scan, and then you'll want to tap on the link. The actual link is down there at the bottom, the SurveyMonkey link. So give that one a try. You can download it now.